And today we have Ashlee and Leslie from Placer Title Company joining us via Zoom to go over probate and trust, which is a hot topic these days. Seems to be a lot of probate and trust sales going on currently.
Yeah, so thank you, Amy, for having us today. And Leslie has many years of experience. She actually just confirmed that it was what, 47 years?
Yes, 47 years. Yes.
So if you guys have any questions or want to pick her brain after, I'll leave her information. Is there a chat in here?
There is.
Yeah. Okay, cool. So yeah, I'll let Leslie take it away, and thank you again.
Good morning, and thank you so much for inviting us. Nowadays there's a lot of the estates that are happening. Oh, you're going to adjust it. Okay. Okay. So the topics that we're going to talk about are trusts and probate. So a lot of real estate properties, you tend to find out in this type of market today, a lot more people are putting their properties in trusts or living trust. They are also called inter vivo trusts. It's basically a living will. Okay. It is, while the individual is alive and well, they're living their life the way they want to as far as their estate is concerned. When it comes to selling property under the name of a trust, there's certain things that as an escrow officer in a title company that we have to review to make sure that the ownership is transferred properly. So if you're looking at a property profile and you get the vesting deed, and the vesting deed shows that it's John and Jane Smith's living trust, the first question you want to ask is, whoever you're dealing with, are they the actual, what we call trustor or settlor? Those are the ones that create the trust, okay? If they're not, and it's a family member representing that estate because they passed, then there's certain levels or steps that we have to take in order to transfer ownership free and clear to the next buyer. So in the case where they're the original trustees, as an escrow company and a title company, we require a trust certification if they're the original individuals that created their trust, okay? The reason for this is we want to make sure that who we're dealing with and you're dealing with are in fact the record owners. We don't require a copy of the trust agreement, which is basically all their provisions in regards to their estate, unless they have passed and we're dealing with a successor trustee. A trust is an entity. So the person that's representing the trust is called a trustee or successor trustee. That's who we have to deal with. But we want to make sure that, again, we're dealing with the correct individual that's representing the trust. Trust agreements, normally they're not public record. Okay. Those are privately owned by the individuals that created the trust. Okay. Was there a question? I thought I heard somebody. So
Nope, you're good.
Anyway, once that, oh, good. Okay. So on the trust, if they're the trust certification basically just confirms who we're dealing with, their ID, and if it's revocable or irrevocable. We don't know that either unless it's a record stating that, or we'd have to look at the trust agreement, okay, to find the provisions.
Can I ask a question?
Yes.
What is the difference between irrevocable and revocable?
A revocable is when the trust provision shows that whoever created the trust can revoke it, dissolve it at any time. If they pass, sometimes most trusts become irrevocable, meaning that the provisions of that trust has to follow through until the end. So, for example, you can have like an investor who has an irrevocable trust that owns multiple properties. So in the trust, there'll be provisions stating that I don't want any of these properties sold. I want my trust to continue on even after I pass into my heirs, and he'll list that. I had one in Vallejo that the investor had 10 properties, and the successor trustee was their attorney. And on it, it states that they were all rentals and investments. So what happened was that any income that came from that trust or trustee had to give all the heirs like an annuity every year. And it just goes on until it no longer exists, or at such time all the successor heirs have agreed to dissolve the trust. Okay. You can basically, the irrevocable is a rarity. It's not common, but I have seen it in my past experience when it's multiple properties and they have a lot of value in it. Okay, so then the original trustee doesn't want to be sold because he knows down the road there's going to be potential for his heirs or beneficiaries. Does that make sense?
Yes, thank you.
Okay, you're welcome. Not a problem. So, and a trust agreement, if the trustee is deceased, we as an escrow company require a certified copy of the death certificate of that trustee. And the reason for that is we have to remove that trustee, if it's of record, by what we call an affidavit of change of trustee. It's a form that we provide. It can be executed by the successor trustee and recorded with attachment of the death certificate, which of course the successor trustee will receive back after recording. Okay. This just tells the public, you and me, that this trustee is no longer alive and that we're going into the next step as far as dealing with the successor trustee. That successor trustee has provisions and responsibilities that they have to follow when an original trustee passes. So in it, it will state, most trusts will state either the properties that are already of record, or it will have a provision in it saying that any property that I acquire or during my lifetime is under my name of my trust. It has happened where some individuals forget to put their properties in trust and it's supposed to be, then that's when you have to go to an attorney and through court to get that property in the name of the trust. I've also had that experience where two properties were supposed to be in the trust and they weren't. So the successor trustee had to go to court to show proof that this was their intent, but they didn't do it while they were alive. Basically, it's something that was forgotten, and it can be done. And it just tells us that, yes, this is under the name of the trust. We record the court order, and then they can sell the property under the trust name. If a property is sold, this is very, very important, under a trust name. If the original trustee or trustors are not alive and the property is sold, the sales proceeds must be in the name of the trust, okay? And if you're instructing us to wire the money, it has to be wired into the account of under the trust name. We can't alleviate from that because there's a reason why these individuals put their properties in trust. So we have to follow that provision throughout, okay? And that's the most common thing that I've seen of when properties are sold is that they will say, oh, can you just put it into my bank account? Unfortunately, we can't because the trust was created for a reason. So it has to be matching into the bank account as well. Now, the question has come to me is there a way that we can put it into our account personally, our personal account? The answer to that question is yes, provided we do have a trust checklist. Placer Title does. I don't know if other title companies do, but the checklist basically tells us if it was the original trustor or settlor that created the trust, if anything happens to them, that the estate remains in the name of the trust. So there's certain true and false questions on this checklist. If they answer all yes, and it's approved through our legal department, then yes, we can put it into their personal bank account. And I have done that in the past, only provided if the person was alive and well that created the trust and sold it. But if it's a successor trustee, unfortunately, we cannot. It has to be under the name of the trust. And then that successor trustee would have to open up a bank account per the provisions of the trust for that estate. Okay, does that make sense to you guys? If I don't, if you just put thumbs up or saying yes, that's fine. I just wanted to make sure.
I
Yes,
feel like
thank
I
you.
encounter that on almost every trust transaction. You have sellers that are scrambling at the last minute to open accounts so that the money can go into an account at the close of escrow. That's like the number one
That is the
scramble.
number one, Amy. Yeah, you're absolutely right. Usually when I get an escrow opened and the preliminary report says it's under a trust, I always ask the agent representing the sellers if I can get a contact information for the sellers, because I ask them those questions, which will give them time to take their trust agreement to their bank to put it into the name of the trust. And you're absolutely right. And then they do get frustrated because they'll ask the question of, well, why didn't my attorney advise me? That's a really good question. Attorneys should advise their trust, their clients to put their bank accounts, because there's a reason for creating a trust. It's for your estate. It's for your heirs, your beneficiaries, your children. You want them to have a future, so you want them to follow suit. And it's very common that 9 out of 10 times a trustee does not have a bank account under their trust name. And I don't understand why, and I don't know why attorneys do not advise them to do so when it's created. Okay, I do know a couple of attorneys that have asked in the past. They do direct them to do that, but they can't force them to do that. So unfortunately, we're at a standstill when it comes to selling real property under the name of a trust. Another question that pops up a lot is a power of attorney. Can a power of attorney be used when a property is vested under the name of a trust? That's a yes and no answer. And the reason for that is the trust agreement must have a provision in the trust that states that a trustee can appoint a successor trustee to be an attorney in fact. The key words in my conversation is successor trustee and trustee. You can have a built-in power of attorney for a durable, which is for health decisions, okay, if they become incapacitated and they have to make a medical decision on their behalf. But that's a separate type of power of attorney. There's 4 types of power of attorneys used in California, but the one that we look for is specific to the property that's being involved or as being sold or purchased. So unfortunately, that has to be provided in the trust agreement. And again, it's not unusual that it's not noted in there. So we cannot use the power of attorney unless there is an actual provision stating that it's in the agreement. And in my past experience, again, a trust agreement, very rarely do I see that provision unless the trustee owns multiple properties and they're very experienced in understanding their trust provisions. I have seen that, but I don't see it very often. Okay. So, it's really, I'd like to use a power of attorney only because we always have to ask the question, well, is the trustee alive and well? Are they capable of signing their name? If they're incapacitated, are they able to resign as a trustee and appoint you as a successor trustee? So there are ways to go around it in order to make it work. And if you have that situation when you're accepting a listing and you know this, please call us. Let us know. I'll be more than happy to guide you on what can be done to get it all fixed before an offer is accepted. And then you don't have this, the delay of your closing, so that everything transfers and free and clear title as far as the trust is concerned. Did you guys have any questions on that? No? I'm going on. Amy, let me know when to stop if there's a question. Okay.
You're good.
Okay, good. All right. So even when the original trustee is deceased, we do need a tax identification number. And the reason for that is for income tax purposes when a property is sold. And of course, the tax identification number is mainly usually the first trustee that created the trust, their social security number. If they are deceased and the estate is complete, then there would be a tax identification number, a TIN or EIN number that's provided from the estate, okay? And we will ask all those questions again up front of what is required in order to transfer title to the next buyer, okay? In regards to that, I think that's the only thing as far as trust. This is just the basic understanding of living trusts, but I'm more than welcome to talk to each one of you if you ever have a situation and you need some guidance or you need some assistance. We're here for you, okay? So the next topic is going to be probates. This one is a little bit more challenging. When you have an estate that you're representing as far as a sale of a property, and it's not under the name of a trust, and the person passed, and there was only one person on title. So when that happens, of course, whoever is making the disclosing that they're going to represent the estate, like the executor or the administrator, that would have to go through probate. And there's 2 types of probates. So one is the Independent Estate Act, and it's with a will. So if there's one without a will, then it does go through, they both go through probate, but the probate for a will is called an administrator, okay? If it's a probate without a will, it's an executor. So that's the difference of how I tell when I see a probate done through an attorney. And we have to have certain guidelines or items that we will need in order for them to pass title under a probate. Okay, so if there is, the first thing we have to ask for is a copy of the probate order that it's been started. And normally, if there is an individual that's going to represent that estate, I always ask who is representing the probate. I always ask for the attorney's name, because the attorney is the one that has to provide an escrow company with certain documents in order to tell us that the probate is complete, that everybody's been notified as far as who they feel that is going to be an heir or beneficiary to the estate. These are documents that are not public record. Some of them are filed within the courts, but they're not recorded in the county where the property is located. We, of course, just need those documents in order to make sure that we transfer ownership properly and that we didn't miss anything. Okay. We just try to find out also if there is a will. The attorney will see if it's considered what we call if it's valid or invalid, as far as if it's being executed properly. Again, we don't ask for the wills. We just go through the attorney representing or the executor, representing the estate and making sure that everything's okay. On the probate, we have an order confirming sale. It's called an OCS. This is a document that is recorded and also filed with the county and the courts. This states that you're representing the estate and you're going to sell the property. On that, it's going to give us the terms of that sale of all the heirs and beneficiaries that agree to sell this property. One, it's going to say what price is involved. Two, is there going to be commission paid? Three, are there any repairs or any expenses to come out of the sale? And then four, just basically tells us who is to receive the proceeds. Most of the time, all the proceeds, again, have to go into a bank account under the estate of the deceased. Because if the probate is not completed, the executor or the administrator has to wait for the final distribution from the attorney and the courts of who is to receive the balance of the probate, okay, of the proceeds. So those things, again, you'll know in the beginning when you are getting a listing if that individual is deceased or not and what steps need to be taken. So if there's just one individual on title and they are deceased, a probate would have to be involved no matter what. Okay, whether the type of probate, again, that's going to depend on the estate, which is going to be determined by the courts and by the attorney representing that estate. Okay. The notice of proposed action is something that was provided to us up front by the attorney. The attorney just basically tells us that they've appointed a person to be the executor or the administrator of the estate. Okay, and that is just something so that they have with full authority. Full authority meaning that they can sell their property, they can buy a property, but mainly if it's regards to a sale, it's that the property can be sold and the person is authorized to sign on behalf of that estate. This notice of proposed action is a filed document. It does not need to be recorded or public record within the county, but just filed within the courts where the property is situated as far as the ownership is concerned. Then the next step after that is we have to get what we call a notice to creditors. None of us know if the owner has any creditors that are due any kind of debt. If that's the case, this is something that is done through the attorney and representing the estate. And normally the time frame is 3 to 4 months for a creditor to respond or have the right to respond to claim any funds from the sale of the property. If it's a large amount, they have to go to court to request this. So once we get that, and then there's also a letter of administration or a letter of testamentary. These are two types of letters that is presented to us by the attorney that completed the estate that we have to record prior to the grant deed transferring ownership, stating that the executor or the administrator can sign the ownership of this property to the new buyer by this letter. And this is just a document that is approved by the courts and the judge stating that everything's okay on the estate and now the property can be sold properly. Okay. We also require a letter from the attorney representing the estate stating to us that all the heirs and beneficiaries have been notified. It's just an email. We can accept an email just stating that all the beneficiaries and heirs have been notified and all have consented to the sale of the property. So if one of them says that they are contesting the estate, unfortunately, we can't go any further until we have something signed by that person of the reason why they don't want to move forward. I have seen that where we've had one or two contest to the estate being sold or the property, but only because they wanted to buy the property, which can happen. It's just a matter of what is presented at the time of that person is deceased and what happens to the property itself. So yes, and you've seen it too, probably in your past experience, where owners or family members want to keep their grandparents' home because they, grew up there, or their parents' home and they were raised there. And that's okay. It's just making sure that all the other heirs or beneficiaries are in agreement and consent to that transfer. Did you guys have any questions on that? No? Okay. So I'm open to questions. There's different types of transactions as far as experiencing trusts and probates, and each one is unique to the transaction involved as far as the sale of the property. So everything is going to be handled with the same process. It's just that we may deal with more than one person when it comes to an estate, which is okay. We just have to make sure that we have everybody involved taking care of, and handled through the estate so that we're not missing an heir or a beneficiary that's supposed to be paid. Now, as far as a probate, we cannot pay heirs or beneficiaries. This is also under a trust provision separately as far as an estate is concerned. It has to go into the bank account designated by the trustee or the executor or administrator in a probate. They are responsible to distribute the sales proceeds, not an escrow company. And I have been asked that in the past is, can I go ahead and distribute all the heirs their equal portions? Unfortunately, we can't because we have no idea if the property income taxes have been filed for that individual or that estate, and that everything's cleared with the Franchise Tax Board and the Internal Revenue Service. So in that case, all the proceeds must go to an account designated by the person representing the estate, and then they distribute accordingly. Okay? Any questions?
Earlier you had mentioned that there's 4 different types of power of attorneys. I think you said. Can you list what those are?
Yes, there's a general power of attorney. The general power of attorney is for the purpose of the person that they appoint to handle everything in regards to their estate: banks, financial, health, any and all properties. There's also what we call a specific or limited power of attorney. That is for the purpose, and that one is the most common that title companies require when it comes to real property to be sold or purchased, because it has to be limited to just that property. And there's limitations as far as powers, meaning they can only sign if they're doing a purchase, or they can only sign pertaining to a sale of a property. So that's the limited / special power of attorney. It's also called a specific power of attorney. The other one is a durable power of attorney. The durable power of attorney is for health purposes, and that's for the purpose of if the person's unable to make their decisions medically, then that person that's designated as the attorney in fact can make the decisions on their behalf. Okay. And the other one is also a health power of attorney, which is a little bit more extensive, where it has the limitations of medications and also doctor's orders. Those two I've seen, but they've always been incorporated into like a trust as far as the health directives. So that part we don't really review. We only review the special or the limited power of attorneys. I've seen the general. General power of attorneys have been presented to escrow companies before saying, hey, I can buy, I can sell, I can do whatever. Unfortunately, as an escrow company, an agent and title company, we have to make it specific just to the property involved, only because they give them the power to do everything and anything pertaining to that individual's estate. Does that make sense?
I think so. So the durable power of attorney is if somebody's mentally cannot sign.
Correct. If you're using a durable power of attorney for real property, and it can be done if there's a provision in that durable power of attorney that states real property, the important word is hypothecate, because that makes a determination as that is part of your direction being an attorney in fact for that. But in there too, if we're using that, the next question as an escrow agent that I'm going to ask you is that person incapacitated? If so, we would require 2 doctor's letters stating, that they're incapable of making their own decisions. But when it comes to that, this is where it's going to be very, very, it's going to be looked at by our legal department. And the purpose for that is if that individual is alive, but unable to take care of themselves, the next step is that we would not ask for a durable power of attorney. We would ask for a conservatorship. Because the conservatorship is,
okay.
it's going to be for the taking care of that individual as long as they're alive. Okay, so a conservatorship, of course, is going to be appointed by the courts and approved by the courts, saying that yes, you can sell the property, take the proceeds, put it into an account that you're going to be taking care of that individual or individuals for during their life. So that's going to be really a sticky situation when we come to a durable power of attorney, because there's reasons for that. And if it is pertaining to real property, then we have to take it one step higher to legal to make sure that it can be used for the purpose of selling a property. Okay.
So it might be easier if you just get a specific power of attorney.
Specific is a very easiest one and the most common one used because it just lists the property. Now, I have seen it with buyers because we live in the area where there's Travis Air Force Base and there's military. So one of the spouses who's not in the military will come out sooner to purchase a property. So on that, it would say specific on it, but it will say on it, and I have seen it where it says that it's going to be specific to any real property located in Solano County. Okay. So that's okay. We can use it. We would just add the description to the specific power of attorney when we get ready to record.
Okay. Sounds good. Thank you.
You're welcome. Any other questions? If I talk too fast, I do apologize. I get that way sometimes. But other than that, I'm always here for any questions, any assistance, guidance. I've been doing this for 47 years. As Ashlee said, yes. The picture is deceiving because you can't really see me. So then just letting you know that. Okay.
I do have a question. I came in late. I had trouble logging in.
Sure.
I just closed on my first probate sale, and it was a whirlwind. We were supposed to have closed May 15th, and we just closed last week due to the fact that the lawyer kept saying that they needed to approve our appraisal. And they had the appraisal within like 5 days of us going into contract. Okay. And the listing agent kept saying, well, we can't bother the lawyers. We can't bother them. We just have to wait for them to give us the answers. So it took almost a month for them to say, yes, we approve the appraisal and then close. The sellers, the conservator agreed to everything. The heirs agreed to everything. We were just waiting for the appraisal approval. Is that normal?
So this is Yolanda, right? Or is this Gloria? Oh, I'm sorry. So what it is I was going to ask you a question in regards to this probate. Was there an order confirming sale recorded or filed pertaining to that? And that's why the attorney was asking for an appraisal?
I am not sure.
Normally, they won't ask for an appraisal unless it's actually required by the courts for an order confirming sale. So if the property is going to be sold and all the heirs and beneficiaries agree to the property being sold, but nobody has an agreed price, then an order confirming sale is required, which does require an appraisal. But the escrow officer would have received what we call an OCS is the abbreviation, but it's called an order confirming sale. And you can probably look in your paperwork, maybe, like on the seller statement, if they recorded one prior to the grant deed being transferring ownership. So that's the only thing I can tell you. I've never had an attorney under a probate ask for an appraisal unless an order confirming sale had to be ordered by the court as far as the value.
And then for future knowledge, if I were to ever list a probate sale, would that appraisal need to be done ahead of time or only when it's requested?
If you're listing a property and a probate has already been started, there would have been an appraisal done as far as the time of the death, the demise of that individual, because they have to determine the value of that estate for the heirs and the beneficiaries. So that would have been done up front, yes.
Okay.
So when it came to you listing the property, most of that would have already been taken care of. And then all you're waiting for is the notice of proposed action, appointing, a person to be the executor or the administrator of that probate. And then also getting the letters to record stating that, yes, this person can sign on behalf of the estate to sell the property.
Okay, you talked about an appraisal at the time of death. I've been asked a couple of times now to do a market analysis as a realtor at time of death. Do
Okay.
the courts approve that as a value of the property?
They
Or does it
can.
have to be a formal appraisal?
No, it's just basically if you're doing a market analysis, I have seen it where they, also the BPOs, the letters of that, just stating for a value, and they'll usually get 1 or 2 letters from different brokers or realtors as to any market analysis, just to determine a value as far as the area where the property is situated for sale. So I've seen it where they've taken market analysis. It just depends, I want to say, on the estate or the value of the estate. Like how big is it? Do they own multiple properties? That information.
Oh, okay. Okay, thank you.
You're welcome. Any other questions? You can bring up anything, not what we discussed. If you had a situation and you wanted to know if this was correct or how it should have been handled, if it was delaying your escrow. Any situations?
I have a question.
Mhm.
When there's 2 people on title to a property and one of them passes away,
Okay.
how important is it? How much delay does it cause if, say, they just leave the deceased still listed on title with the county until they go to sell the house? Does
Okay.
that cause any kind of delays in the process of selling or doing anything with the property? Should,
Yes.
I guess my question is, should when somebody passes, that person be removed and recorded with the county? Or since a trust was put in place after that person deceased and was updated by an attorney, but not recorded with the county, I'm just wondering how important it is that there's a follow through on the documents, updated documents getting recorded with the county.
Okay.
Does that make sense? Does that cause
Yeah.
delays when people don't do that?
Well, the first question is if there's 2 people that are vested on the property, the first thing we want to look at is how are they vested? Are they joint tenants? Are they tenants in common? Are they married to each other? If they are married to each other, did they take title as community property? So there's questions pertaining to how they vested. So say, for example, you mentioned that one of them passes, so there's one left, and then that person put it into their trust. Is that what happened or could happen? If that was the case, then it sounds like they may have taken title as joint tenants, which means the right of survivorship equals shares. So when one of the people passes, their estate goes to the surviving joint tenant. That joint tenant becomes the sole owner. And then at such time, yes, they can put it in or create a trust and put it into their trust name. If we as a title company see or examine the property search or the documents, if it wasn't done properly, then we would give you notice to let you know that something needs to be corrected. Other than that, we would just look at what we call a chain of title on how was this handled? Was it prepared by an attorney? If it was, the good news that most attorneys would know the proper transfer. If they are a real property attorney or real estate law attorney, because I have seen it with attorneys that are family law, but missed a step when it came to transferring ownership from an individual into a trust, and they didn't record an affidavit. And that can be corrected when the property is sold. We can record an affidavit just to cover the steps of the chain of title. Does that make sense?
Yeah, that makes sense. Thank you.
You're welcome. Any other questions? If not, I thank everybody for joining this meeting. And if there is, my name is Leslie Stewart, and you have our phone number here at Placer Title. And of course, Ashlee can also bring she can bring back any questions you may have, or if you want me to come to your office in person, I'll be more than happy to sit down with you, or you're welcome to come to our office. If you want a little bit more education, I'm here for you.
Thank you very much. It was very, very informative and cleared up a lot of questions.
Okay. And Ashlee, you did drop off a lot of these.
Yes.
Yes.
Mhm.
Okay, so we have the trusts, you know, the FAQs and also for the probates. But if there's something that I missed as far as going over this, please let us know and I'll be more than happy to get everything clarified for you should you need some more information.
And Carly will be adding those documents, the FAQs and such, into the Foxhole Facebook group as documents. So you guys will be able to access those there. Please make sure to log your attendance in the chat box. There's a link for that. And thank you so much, Leslie, for your knowledge and expertise today when it comes to probate and trust, because I know that's it, you know, everybody kind of gets confused when it comes to those items. So I really appreciate you coming and walking us through that process and answering questions.
Thank you so much, Amy. Appreciate it.
Yeah.
Thank
All right,
you.
guys. Thank you.
Thank you.